What if one ordinary moment could suddenly pull you into one of the most powerful systems in the world? Imagine waking up on a normal morning in the United States. You grab coffee, check your phone, and head to work like any other day. But before lunch, a letter arrives. It's not just any letter, it's from a court. Your heart beats a little faster. Inside that envelope is a summons. Maybe you're called to serve on a jury. Maybe you're involved in a lawsuit. Or maybe you're accused of something you never expected. At that moment, you are no longer just an ordinary citizen. You are now part of the American legal system. A system built over more than 2 centuries. A system designed to balance power, protect rights, and ensure that even the most powerful people must answer to the law. But how does that system actually work? How does a simple dispute between 2 people travel through layers of judges, lawyers, evidence, rules, and arguments until a final decision is made? To understand that story, we have to step inside an American courtroom. The courtroom is quieter than most people expect. Sunlight passes through tall windows and falls across polished wooden benches. At the front of the room sits the judge's bench, elevated slightly above the rest of the room. This elevation is not just for visibility, it symbolizes authority and neutrality. Behind that bench sits the judge, the person responsible for ensuring that the rules of law are followed fairly. On one side of the courtroom sits the plaintiff, or the prosecution. On the other side sits the defendant. Between them lies the central battlefield of ideas, evidence, arguments, and legal reasoning. But before a case even reaches this room, a long process has already begun. In the United States, the legal system operates under a structure built by the Constitution. That document created a government divided into 3 branches: legislative, executive, and judicial. The judicial branch is responsible for interpreting the law. Courts do not make laws. They do not enforce laws. Instead, they determine what the law means and whether it has been applied correctly. This system exists at both the federal level and the state level. That means there are actually 2 major court systems operating parallel throughout the country. Federal courts handle cases involving federal laws, constitutional questions, disputes between states, or issues involving citizens of different states. State courts handle most everyday legal matters, including criminal cases, family disputes, property conflicts, and contract disagreements. Most Americans who encounter the legal system will enter through the state courts. The journey often begins when someone files a complaint. Imagine 2 business partners who once trusted each other completely. They built a small company together. At first, everything worked smoothly. They shared profits, responsibilities, and dreams for the future. But success sometimes changes relationships. One partner begins to believe the other has been hiding profits. The trust collapses. Arguments turn into accusations. Eventually, one partner hires a lawyer. That lawyer prepares a legal document called a complaint. The complaint outlines what happened, what harm was caused, and what the plaintiff wants the court to do about it. This document is officially filed with the court. Once filed, the legal machinery begins to move. The court issues a summons to the defendant. The defendant then must respond, usually with a document called an answer. This response may admit some claims, deny others, and sometimes present counterclaims. At this stage, the battle lines are drawn. But the American court system rarely jumps immediately to trial. Instead, one of the most important phases begins: discovery. Discovery is a process where both sides exchange information. Each side has the right to request documents, ask written questions, and even question witnesses under oath. Lawyers may conduct depositions, which are recorded interviews with witnesses. During these sessions, attorneys ask detailed questions, while a court reporter records every word. These depositions can last hours or even days. Why is this process so important? Because American law is based heavily on transparency and fairness. Neither side should be surprised at trial by hidden evidence. Both parties must know what information exists so they can prepare their arguments. Sometimes discovery reveals weaknesses in a case. A witness may contradict earlier statements. Documents might show a misunderstanding rather than intentional wrongdoing. Because of this, many cases never reach trial. Instead, they end in settlement. A settlement occurs when both sides agree on a resolution without asking a judge or jury to decide. Settlements save time, money, and uncertainty. However, when settlement fails, the case moves closer to trial. Before trial, judges often hold hearings to resolve legal questions. Lawyers may argue about whether certain evidence should be allowed. They may ask the judge to dismiss parts of the case. These motions can shape the entire outcome before the jury even hears a word. Eventually, if the case survives these challenges, the trial begins. For many Americans, the most fascinating part of the legal system is the jury. The idea that ordinary citizens can decide the outcome of serious legal disputes is a cornerstone of American democracy. Juries are selected from the community. Potential jurors receive summons letters asking them to appear at the courthouse. When they arrive, lawyers question them during a process called voir dire. The purpose is to identify potential biases. If someone already believes strongly in one side of the case, they may be excused. The goal is to create a fair and impartial jury. Once the jury is chosen, the trial begins with opening statements. Opening statements are not arguments. Instead, they are roadmaps. Each lawyer explains what they believe the evidence will show. The prosecution or plaintiff goes first. They describe the story they intend to prove. Then the defense responds, offering a different interpretation of the same events. After opening statements, the evidence phase begins. Witnesses take the stand one by one. Each witness swears an oath to tell the truth. Lawyers ask questions to draw out the facts. The side that calls the witness conducts direct examination. Then the opposing lawyer conducts cross-examination. Cross-examination is often the most dramatic part of a trial. A skilled attorney may challenge a witness's memory, credibility, or interpretation. Documents, photographs, and recordings may be introduced as evidence. Every piece of evidence must follow strict rules. If evidence was obtained illegally or improperly, the judge may exclude it. These rules protect fairness and prevent abuse of power. Throughout the trial, the judge acts as a referee. The judge does not decide who wins in a jury trial. Instead, the judge ensures the law is followed and the proceedings remain orderly. When all evidence has been presented, both sides deliver closing arguments. Unlike opening statements, closing arguments are persuasive. Lawyers summarize the evidence and explain why it supports their side. They connect the facts to the law. They remind jurors of testimony and highlight contradictions. After closing arguments, the judge gives instructions to the jury. These instructions explain the legal standards they must apply. For example, in criminal cases, jurors must decide whether the defendant is guilty beyond a reasonable doubt. This is the highest burden of proof in the legal system. It reflects the belief that it is better for a guilty person to go free than for an innocent person to be wrongly convicted. The jury then leaves the courtroom and enters a private deliberation room. There, they discuss the case among themselves. They examine the evidence. They debate interpretations. Sometimes deliberations take only a few hours. Other times, they can last days. Eventually, the jury reaches a verdict. When they return to the courtroom, the entire room becomes silent. The foreperson stands and announces the decision. In criminal cases, the verdict may be guilty or not guilty. In civil cases, the jury may determine damages or responsibility. But even after a verdict, the story may not be over. The losing party often has the right to appeal. Appeals do not involve new evidence or new witnesses. Instead, appellate courts review the trial to determine whether legal errors occurred. If a judge misapplied the law or allowed improper evidence, an appellate court may order a new trial. Above the appellate courts sits the highest court in the country. That court is the Supreme Court of the United States. This court hears only a small number of cases each year, but the cases it chooses often shape the meaning of the Constitution for generations. Decisions from this court can redefine rights, limits on government power, and the interpretation of federal law. What makes the American court system remarkable is not just its structure, it is the philosophy behind it. The system assumes that power must be limited. No judge rules forever without oversight. No prosecutor wins automatically. No defendant is presumed guilty. Every step of the process is designed to create balance. Lawyers challenge each other. Judges supervise the process. Jurors represent the public. Appellate courts review mistakes, and the Constitution acts as the ultimate framework guiding it all. Over time, this structure has handled everything from small neighborhood disputes to the most consequential issues in national history. Civil rights cases, freedom of speech debates, questions about presidential authority. All of these conflicts eventually passed through courtrooms where evidence was examined and arguments were tested. For many Americans, the legal system is both intimidating and reassuring. It is intimidating because of its complexity. Rules, procedures, and legal language can feel overwhelming. But it is reassuring because it offers a path for resolving conflicts without violence. Instead of settling disputes through force, people bring their arguments to a courtroom. There, facts and laws decide the outcome. This idea that justice should come from reasoned judgment rather than raw power is one of the defining principles of the American legal tradition. And every day, across thousands of courtrooms in cities and small towns, that tradition continues. Judges enter their benches, lawyers prepare their arguments, jurors take their seats, witnesses raise their hands and swear to tell the truth. Another case begins, another story unfolds, and the quiet machinery of justice moves forward, one decision at a time.